let's talk some more about this Bill Thompson Brady List issue, because I'm still seeing a lot of people misunderstanding it. When I put out the video 3 weeks ago, I kind of anticipated that if some other content creators got a hold of it, that they were going to blow it up into something it wasn't. And I was trying to preempt that, but obviously my video didn't preempt the shit show that's currently going on YouTube. But hopefully I can give you a better understanding of Brady Giglio and Brady Lists. So I'm going to start first with an understanding of Brady, the Brady ruling, and then Giglio, so that you understand what Brady Giglio material is. And then we'll lead into what a Brady List is. So I always go to WEX, which is the Legal Information Institute Library. It's handled by Cornell Law School. That's where I was trained to look everything up for legal items. And it says the Brady Rule is named after Brady v. Maryland. Now, that was a landmark Supreme Court case because it changed how things were done with trials as far as discovery. And it requires prosecutors to disclose material, exculpatory information in the government's possession to the defense. Brady material, or the evidence the prosecutor is required to disclose under this rule, includes any information favorable to the accused which may reduce a defendant's potential sentence, go against the credibility of an unfavorable witness, or otherwise allow a jury to infer against the defendant's guilt. Initially, the Brady Rule was only applicable if the defendant made a pretrial request for specific information, which the prosecution denied. In United States v. Bagley, however, the Supreme Court eliminated this request requirement and stated that the prosecution has a constitutional duty to disclose all material, favorable information in their possession to the defendants, regardless of whether it is requested. This duty is breached regardless of whether that information is withheld intentionally or unintentionally. If Brady Rule violation is discovered during the trial, the court can either declare a mistrial or prohibit the prosecution from using the unfavorable evidence, which could be discredited by the withheld information. Because the Brady Rule inherently involves a lack of information on the side of the defense, however, violations of Brady are typically only discovered after the defendant is already convicted. As a result, the most common outcome of a Brady violation is overturning that conviction. Additionally, if the prosecution withheld Brady material intentionally or knowingly, they may be subject to sanctions. Now, Brady material is derived from the Brady v. Maryland case. It has established a rule that the prosecution has a constitutional duty of due process to disclose material evidence favorable to a defendant. Later in the State v. Carter, the court found that such evidence should be 1, material to the issue and not merely cumulative or impeaching or contradictory, 2, discovered since the trial and not discoverable by reasonable diligence beforehand, and 3, of the sort that would probably change the jury's verdict if a new trial were granted. In practice, if the prosecutor suppresses or fails to disclose evidence that is material to the defendant's guilt verdict or sentence or influences the credibility of a witness, no matter whether the prosecution is of good or bad faith, intentionally or inadvertently, the defendant can use the Brady material to get a new trial. See United States v. Bagley again. The prosecutor is not required to disclose entire files, but only impeachment or exculpatory evidence to the defense counsel, regardless of whether the evidence is in their possession or not, or whether they are asked to do so or not. To be more specific, the prosecutor has an affirmative duty to search their files and files of law enforcement officers who work on the case for material evidence. As to the defendant, they are required to demonstrate that if such material evidence is disclosed and used effectively, it might affect the outcome of the trial or undermine confidence in the verdict. The Brady material has 3 components. The evidence at issue must be favorable to the accused, either because it is exculpatory or because it is impeaching. That evidence must have been suppressed by the state, either willfully or inadvertently, and prejudice must have ensued. concluded the Strickler versus Green case. Once the above elements contend, then a Brady violation is established. That is a Brady violation, withholding anything favorable to the defendant. What Bill Thompson is posted on that one website is not a Brady violation. Okay, that's somebody complaining about him claiming bias. That's not a Brady violation. A Brady violation is a prosecutor withholding information favorable to the defendant. Now, Giglio comes into this because under that ruling, the Supreme Court determined that if any deals were made with a witness, that it has to be disclosed to the defendant. So when you hear Brady Giglio, that's basically the whole gamut of anything favorable to the defendant. So that includes if any deals were made to anybody that's going to be testifying in the case. Now, I found a slideshow that was put together that explains things really well as well. So I'm going to go through that on here. Okay, this was actually a presentation for law enforcement, and I'm giving credit to the people that created it, Bill Amato and Captain Aaron Jones. It's called Brady Giglio and Officer Integrity. And it gives you a background to Brady versus Maryland, 1963 capital murder case. Government had a duty to disclose material exculpatory evidence. Failure to do so violated due process where the evidence is material to either guilty, innocence of the accused, or punishment. And then there is no regard for good or bad faith of the prosecutor. So it doesn't matter if it was inadvertent. Under the Constitution, due process requires the prosecution to turn over evidence favorable to the accused and material of his guilt or punishment. This requirement includes evidence that may be used to impeach the prosecutor's witnesses, including police officers. And that is where Brady Lists come from. Goes on to say police officers and police agencies are, for purposes of Brady, considered to be part of the prosecution team. They must therefore make the prosecutor aware of any evidence that may be favorable to the accused. Then U.S. versus Giglio, Brady rule includes evidence that could be used to impeach a witness. When the reliability of a given witness may be determinative of guilt or innocence, non-disclosure of evidence affecting the credibility falls within the rule, regardless of whether withheld in good faith. Then you have U.S. versus Bagley. No legal distinction between exculpatory evidence and impeachment of evidence for purposes of the Brady rule. Favorable evidence is material if there is a reasonable probability that the result would have been different if the defense had known. Harmless error standard does not apply. Issue is whether evidence is material. And then Kiles versus Whitley said that knowledge imputed to the prosecution includes knowledge that the police may have. The prosecutor has a duty to learn of any favorable evidence known to others acting on behalf of the government. That includes the police. And here are some examples of impeachment and exculpatory evidence. It says government obligation to disclose favorable evidence under Brady covers not only material exculpatory evidence, but also information that could impeach government witnesses. Agreements exchanging testimony for money or favorable treatment, the fact the witness suffers from hallucinations, efforts by one witness to improperly influence the testimony of another witness, history of untruthfulness, and other conflicting statements made by witnesses. Those are all examples. And then material exculpatory evidence examples are prior inconsistent statements of key witnesses, government witnesses that had previously filed a false report, information undermining the credibility of witness identification of a defendant, doctor's report following an autopsy which conflicts with later trial testimony. Okay, some more examples. Detective Jones is handling a rape investigation and develops information of a potential suspect who was seen leaving the scene in a white pickup truck. The investigator displays a photo lineup to the victim and she identifies the suspect, who does own the white pickup. No forensic evidence connecting the suspect to the crime is initially discovered. During the course of the investigation, a witness is located during the area canvass who claims to have seen a beige pickup truck in the area driven by a dark-skinned male in his 30s. The identified suspect is a light-skinned male in his 20s. The investigator does not document this information in his report because it contradicts the probable cause he has developed in his case. So you can see how he just ignored something that could be exculpatory to the suspect they've pulled in. Okay, here's another exculpatory example. Detective Smith is handling a murder investigation. He develops a suspect who is of limited intelligence and brings him into the station for questioning. After questioning him over a period of days, he informs the suspect that if he confesses, he will be allowed to go home. The suspect confesses and is taken into custody and charged with murder. Detective Smith failed to document his promise of allowing the suspect to go home in exchange for confessing, and he does not inform the prosecutor. Detective White is handling a robbery investigation in which a victim is shot. He discovers a footprint near the scene, which he has photographed and lifted. He subsequently arrests a suspect who is wearing a size 9 shoe. The footprint is a size 11 sneaker, and Detective White discards the footprint evidence, believing it is unrelated to the crime. He fails to document the information. Okay, another example. Detective Evans displays photo lineups to 3 witnesses. 2 of the witnesses identify a suspect, however, the 3rd witness fails to identify anybody. Detective Evans documents the 2 positive IDs, but does not document that the 3rd witness failed to ID the suspect, and Detective Evans never informs the prosecutor. Brady rule examples: officer credibility concerns. Officer investigated, but no finding of violation. Internal affairs finding that the officer had violated policy, not relevant or unrelated to truthfulness. Internal affairs finding that the officer made a false or misleading report or statement. Internal affairs finding that the officer had violated a policy touching on relevant trait or trial issue. And internal affairs finding that the officer covered up or attempted to cover up. So that's touching on things that can land an officer on the Brady list. So it's talking about things that would impeach their credibility. And they should be telling the prosecutor all these things so that the prosecutor can turn this information over to the defense. And when it doesn't get turned over to the defense, then that is a Brady violation. And then, yes, the prosecutor can face sanctions. But those things being done by an officer can also get an officer put onto the Brady list. So let's continue with the slideshow. Okay, Strickler versus Green ruling. That was the 3 essential components of a Brady claim are: evidence favorable to the defendant because it is exculpatory or impeaching, the state willfully or inadvertently suppressed the evidence, and prejudice resulted. And then Brady and law enforcement organizations and their employees. This is a question for them. Does Brady mean we have to disclose evidence that does not show the defendant to be innocent, but merely cast doubt on the testimony of the prosecuting witness? And the answer is yes. That has to be turned over to the defense. That needs to be told to the prosecutor so that he can turn it over to the defense. Okay, this section is untruthfulness and bias. So the term untruthfulness refers to false statements, false reports, or intentionally incomplete statements and reports. The false statements involve all aspects of the job, not just enforcement and criminal investigations. See Drury versus Gloucester. It was a 10-year-old disciplinary finding that an officer falsified overtime records admitted for impeachment purposes. And then Williams, United States versus Williams, a new trial was ordered because the FBI had failed to disclose that an agent who was a witness at trial had 15 years earlier received a letter of reprimand for forging an informant's signature on a receipt and lying about the forgery under oath. And then bias includes prior records allegedly showing an officer's bias against an identifiable group, i.e. African Americans or gays. Bias could also be shown towards a particular person or family based upon prior conduct or statements. Crimes. Crimes committed by officers which must be disclosed include any crimes other than motor vehicle misdemeanors, domestic violence or DUI. Even motor vehicle offenses must be disclosed to the prosecutor when the criminal case involves similar conduct. Then Brady and law enforcement organizations and officers. The belief that internal affairs files are confidential and not subject to disclosure is mistaken. The adage that the defendant is on trial, not the officer, has been substantially eroded. In certain circumstances, the officer's prior conduct is relevant in the criminal trial because that conduct reflects on the officer's credibility. Are pending investigations of an officer subject to disclosure? Disclosure will assure the integrity of a criminal conviction. The general rule is that unverified or speculative information is not subject to disclosure. However, the decision to disclose such information is best left to the prosecutor. Potential Brady material affecting officers. Misconduct involving moral turpitude, untruthfulness, bias, moral turpitude, integrity, misdemeanor convictions involving moral turpitude, contrary statements about facts of the case, evidence undermining the officer's expertise, false reports by the officer in other cases, evidence of drug or alcohol addiction. Ultimate use of the information. Brady information must be disclosed to the prosecutor. The prosecutor must then decide whether to disclose the information to the defense. It is very possible, however, that the information may not be admissible in court. Only that evidence which the court finds to be relevant for impeachment purposes can be used. The bottom line, the department officer should make sure the prosecutor is aware of any information about the officer that, if revealed, would be favorable to the defense. The department must disclose to the prosecutor anything in the officer's background that reflects bias, untruthfulness, and criminal activity. The responsibility to disclose the information belongs to the prosecutor. Let them make the decision. You do not want the agency officer to be held responsible for retrial of a case due to non-disclosure to the prosecution. All of this applies to both felony and misdemeanor cases. And then the prosecutor's ultimate role is to obtain information, review information, disclose information, and argue the information. So that brings us to Brady Lists. The Brady versus Maryland ruling did not set up a specific way that prosecutors must handle getting the information and then disclosing it to the defense. But what many prosecutors did was established a list. It's up to each jurisdiction. It's handled at the city level, county level, state level. There's no federal guideline. Some states have enacted state laws that state there must be a list or a database and what needs to go on it, and a formal process for how officers are put on it and whether they can be removed or not. Some prosecutors don't do lists. They just keep things in their memory, or they find out things as they go and then give them to the defense. It's all up to the prosecutor, or whether the state has put a law into effect for all the prosecutors in the state. So the prosecutor is who is in charge of a Brady list, if there is a list. Okay? Any official list comes from the jurisdiction that the prosecutor is in. It does not come from some national website or database. Okay? It's only an official Brady list if it's done by the prosecutor in that city, county, state. So let's continue with some more information about the Brady list. Okay, Brady list. A Giglio or Brady list is a list compiled usually by a prosecutor's office or a police department containing the names and details of law enforcement officers who have sustained incidents of untruthfulness, criminal convictions, candor issues, or some other type of issue, placing their credibility into question. Placement on the list. Police departments/agencies must disclose information regarding potential Brady Giglio material to prosecutors. Prosecutors will then review the information to determine what actions will be taken next. Okay, it says placement on the list. Both the law enforcement agency and the prosecutor's office should maintain the list of disclosures. Prosecutors will then review the disclosures and make case-by-case determination as to how to handle the information. What actual issues trigger a Brady disclosure to prosecutors? The following is not about exculpatory evidence, referring to acts and incidents involving law enforcement officers that could call their credibility into question, and not just acts of dishonesty. Consequences of placement on the Brady List. Stigma or damage to officers' reputation, limits job assignments, limit advancements through the agency, possible termination if the officer is no longer credible to give testimony and no other administrative assignment is available in the department. If you are a chief or a sheriff, what do you do? I mean, this was asking them. Can an officer be removed from the list? An original disclosure that is later determined to be unfounded or not sustained could be basis to remove the officer from the list. Some courts have required removal from the list after an arbitrator has exonerated the officer. And that depends, says great lawyer answer. And that really does depend, because it depends on if that state has a formal process or if it's just the prosecutor's discretion. But as you can see, if there's a Brady list, prosecutors aren't on them. Okay? It is a list of law enforcement officers that basically, some prosecutors call it a do not call list. It's the people they don't want being witnesses in any trial, if they can help it, because there's credibility issues and that witness can be impeached. So that is who is on Brady lists. So let's talk about this website that Bill Thompson is on. Okay, so here's the webpage. It's under giglio-bradylists.com. And it says, to ensure fair trials, the Supreme Court of the United States created the Brady Doctrine. So he's talking about, disclosing the information, of course, like we just talked about. It says the Brady List is a definitive public-facing platform of record for information about officer misconduct, decertification, public complaints, use of force reports, do not call listings, and more potential impeachment disclosure. It's available as a service to all peace officer standards, departments, prosecutors, etc. Well, but he talks about how it's for the Brady process, but yet that acknowledges that Brady material is about witnesses, about law enforcement that's going to be witnesses at the trial, or also if you have to disclose things about witnesses that have taken deals, etc. But not all jurisdictions make their Brady list public. So unless he actually has information off an official Brady list, everything he's taking is just off anything he can glean off the internet. So people can go on there and make complaints. He's taking those and putting them on there. He's scouring to see any states that have released information about decertifications of police officers. Now, Idaho does put decertifications out publicly. But for law enforcement officers that are not decertified, Idaho doesn't put anything out there like that. Most states don't. Most don't put out who has gone under an internal affairs investigation or who is on a Brady list. So this guy is literally just scouring to find whatever he can to put on this list. But let's continue. Now, the creator of this webpage is Johan Drolshagen, and he is a web developer. He lived in Seattle at one point, according to an Oklahoma news channel. He's now in California. He designs web pages. He's not a lawyer. He's not anybody official. And the first entry on the webpage is George Gascon, the Los Angeles District Attorney. But if you notice, he couldn't even spell George's name right in the listing. Now, I don't know if that's because Johan put the listing there or a public complaint was lodged. So a member of the public posted a complaint and spelled George's name wrong. But that's on the front page, just glaring at you. Take that how you will. And here's the buttons you can push to file officer complaint, file a prosecutor complaint, So again, anybody can go on there, and that's what happened with the entry about Bill Thompson. Now, if you notice, it says request a removal. So if you click on it, it says in order to change or remove items from the Brady List, supporting documents will be required by the employing organization, prosecutor, or reasonable post department. Well, obviously, if a member of the public wanted to come on here and request a removal, they're not going to be, because they're going to have to get all this information. And there's no way any prosecutor or police department's going to give you this employee file information. So guess how the only way something can get removed off this guy's website? That is if the agency themselves requests the removal and gives him those supporting documents. And guess what? An agency has to pay to use the website. Oh, he's got his little pricing right here. So $150 a month for all LEO organizations, prosecutors, and post departments that sign up on an individual basis. $75 a month for counties that commit to every single LEO or prosecutor's office, and $35 a month for states that commit every single LEO office, prosecutor's office, and post department in the state. And if you look right here, all plans are invoiced annually and paid in advance. Civilian oversight committees are offered accounts at a reduced cost. Citizens and members of the press are welcome to use this platform for free. So yes, citizens and the press can come on here and file complaints until their heart's content. And then if somebody wants to get a bogus complaint removed, they're going to need all of those personnel documents or other documents from the prosecutor or the law enforcement organization. So guess what that means? That organization's going to have to pay to go on there to try to get that removed. Oh, and have you seen the invoices he sends out? Here's one of them that he sent to the federal government. He wanted $25 million for the United States government to be able to use his website. And Level Playing Field is the company he started that he does the website from. He also sent an invoice to Idaho. He sends one to all 50 states because, as I said before, he has all 50 states' law enforcement agencies, prosecutors' offices, every agency you can think of on his website claiming that they're in violation. And then he sends these invoices out trying to get them to pay up. Folks, it is a scam. It is a money-making scheme. He claims that he's doing a public service, that he's wanting to compile all of these bad officers and judges and prosecutors onto one web page. But first of all, he's deceptive and making people think that it's like a real Brady list. But then he lets anybody on there to file a complaint. And if you want to try to get it removed, you have to go through a whole bunch of hoops that eventually require that agency to have to be the one to try to get it removed. And then they have to pay to use the website. So it's a scam. A scam. And the news station in Oklahoma that did the article about it stated this at the end of their report. This was KOCO News, and they said everything listed on the website is just a complaint and does not mean it has been investigated or verified. So now let's take a look at the complaint that's on there about Bill Thompson. So if you notice, he puts the Idaho seal on there. And I've seen a lot of people making comments in the last couple days that, it must be official because the state of Idaho seal is on there. He has all 50 states' seals. He puts them on all of the listings for that particular person's state. It doesn't mean it's official. Okay, then you'll see prosecutor misconduct number, blah, blah, blah. That number is not an official number. That's assigned by this website. That is not a bar association misconduct number, an investigation number, nothing. That is just assigned by this Brady Giglio website. So if you click on that number, it brings you to this page, and it says date of offense, and then it says offense bias, and then supporting documents, and it has a whole bunch of files. Well, those files are from a woman who is upset that Bill Thompson closed a case, apparently. So the person filing the complaint said, I was informed by my ex-husband's attorney that the case against him was closed. I was never contacted by the prosecutor, despite there being a ridiculous amount of evidence of our abuser's admissions. They include financial, emotional, sexual stalking, protection order violation, and child abuse. Due to the negligence, my child is still experiencing neglect and physical abuse. There is more documentation from when I reported, as well as in the last 8, nearly 9 months. If you go through all of that person's supporting documents, not one of them shows bias. There's nothing that proves bias. They are comments from her ex. They are comments from her. They are a screenshot of like a GoFundMe that she had that shows her ex-husband donated to the GoFundMe. There's pictures of like some bruises on her child, but nothing that shows like medical records, how he obtained those bruises, whether it was abuse or whether the kid fell or whether, so there's nothing that proves bias. Obviously, if Bill Thompson closed the case, there was a reason for the case to be closed. Now, there is no case file on Idaho's court website, which means her ex-husband was never charged with anything. So the only thing I could think is maybe she went into law enforcement and said, hey, I want him arrested. And they investigated and then showed it to Bill Thompson. And he said, hey, there's no charges here. Like, if I took this before a jury, they'd never convict, type of thing. Also, she's talking about a restraining order. Well, I found a protection order in Whitman County. Not one in Latah, but one in Whitman. And the judge renewed the temporary order, but then in September of last year, he declined to extend it, and he terminated the protection order. So I'm not finding any violations of a protection order, like she said in that statement, nothing. So it seems to me like it's somebody that was just upset that law enforcement wouldn't charge her ex-husband and wouldn't pursue a case against them. Now, it does say on this Brady website that it was forwarded to the State Bar Association. So I went to the Idaho State Bar website to see if I could find anything that might show whether this was actually forwarded, but there's no way to know. You'd have to file a FOIA request. But as of this time, there is no discipline against Bill Thompson. So on the Idaho Bar website, I just wanted to see what the time frame for discipline might be. And if there was a hearing on it, it says the hearing committee shall render its decision within 21 days following the date upon which a record is submitted to the hearing committee, or the date of the telephone hearing, if any, whichever is later. So now these are the different sanctions that can happen to an attorney. As I was saying, they don't get put on any sort of Brady list. A Brady list is for law enforcement. So if there is misconduct by an attorney or prosecutor, then these sanctions can happen. The worst, of course, is disbarment. Then there's resignation in lieu of disciplinary proceedings. Okay, then you have suspension, public censure, public reprimand, probation, private reprimand, informal admonition, I cannot say that word, admonition, restitution, and imposition of costs. Now on the bar page, you can look up public discipline and notices, and it says that there are 2 types of disciplinary sanctions, the public and the private. And the public go on here, and I looked on here, and Bill Thompson has no public sanctions. So there are no sanctions listed publicly for him. Now, could there have been some sort of private sanction? Maybe. If that person's complaint was truly turned over to the bar, that complaint was December of last year. So, obviously, if it was reviewed, there would have been some sort of decision already made on it. So, the public sanctions are the worst ones. So if there was any discipline against Bill brought from that, it obviously wasn't any sort of public discipline or public sanction, because it would show on the bar website. And his bar listing is also showing in good standing. So This is much ado about nothing. The bottom line, Brady Lists, if a prosecutor has one, or if a state requires one, is a list of officers who have credibility issues, law enforcement officers, that might be witnesses in a trial. And so they need to be on some sort of list so that it can be turned over to the defense so that they know that there's a credibility issue with that person. A Brady violation is when the prosecutor does not turn over information favorable to the defendant. Okay? Prosecutors and judges do not go on Brady lists. That's not how it works. Being on a Brady list is not a Brady violation. As I just said, a Brady violation is not turning over information favorable to the prosecution or to the defense. So, Bill Thompson being on this Brady list is much ado about nothing. But, of course, it got the usual grifters all in a tizzy. And now you see people in comment sections of all kinds of videos on YouTube and TikTok both saying that Bill Thompson's in trouble and Bill Thompson's on the Brady list and yada, yada, yada. And he's not in trouble. He's not on a Brady list. So hopefully this was educational. And as always, if you have anything you'd like me to cover, let me know.